Welcome to In the Name of the Law with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Law Firm, along with Mary Chartier and Takura Nyamfukudza from Chartier Nyamfukudza PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people and real cases. Today we're going to talk about what you need to know about motor vehicle crashes, the impact of solitary confinement for prisoners, and domestic violence in family law cases. Stay tuned.
In the name of personal injury law.
No one thinks they're going to be in an automobile crash, but unfortunately it happens to many Michiganders every year. Today we have Steve Sinas of the Sinas Law Firm to answer some critical questions about auto crash cases. Welcome.
Thanks for having me.
So, who pays for the vehicle damage when there's an automobile crash?
This is a question we get often at our law firm, and the answer is when you're in an automobile crash, if it's someone else's fault, you still first turn to your own insurance coverage if you have that for your vehicle, and your insurance company will pay your vehicle damage. If they make you pay a deductible, you can pursue that recovery from the at-fault driver. And if you don't have insurance on your vehicle, you can pursue your vehicle damage from the at-fault driver, but it's capped at $3,000. So there can be unfortunate situations where people have a loan on a car, they owe a lot of money on the car, and the car is totaled. And if they didn't have proper insurance on the car, they only can get $3,000, and that can be an unfortunate reality for people to face.
If a person's injured in a car crash in Michigan, who pays for their medical expenses?
The answer to who pays a person's medical expenses begins with the Michigan no-fault insurance law governs people's rights who are injured in a motor vehicle accident. And under that law, people have a right to pursue no-fault benefits. And one of those benefits is coverage for your medical expenses. Whether a person has the right to pursue no-fault benefits depends on the coverage they have in their own household for auto insurance and some other factors that determine and affect whether a person has the right to pursue these benefits. But if you make that determination that there is the right, the person can pursue whatever is reasonably necessary for their care, recovery, and rehabilitation of their injuries. However, that coverage may be capped. It can be lifetime, depending on the coverage you have in your household, or it could be limited to $500,000, or $250,000, or $50,000. It all depends on the coverage you have available to you.
So how should an injured person pursue their medical treatment if they've been injured in a Michigan auto crash?
One thing I say to clients is that you should pursue medical treatment in the same way that you would pursue medical treatment for any other injury or condition you sustain in life. You pursue the treatment you need, no more, no less. As far as the logistics go, you need to understand what type of no-fault coverage you have, the extent to which it covers your medical expenses, and then there's also this issue about whether you have coordinated no-fault or uncoordinated no-fault. If it's coordinated, that means your health insurance has to pay first. So the practical pointer here is that you have to understand your own no-fault insurance coverage, understand whether other types of health insurance coverage is supposed to also pay, and then make sure your providers have the information about all those coverages so that they know who to bill and that the bills get to the right insurance company.
Who pays for the lost income when a person's injured in a Michigan car crash?
When a person's injured and they can't perform their job and so therefore they lose income, they can pursue their income loss through their no-fault benefits. There's a no-fault benefit known as the work loss benefit that covers 85% of their gross income, and it's covered up to 3 years. So there is a good right to pursue there. If the person has an income loss over and above what's covered by their no-fault benefits, they can pursue that excess income loss from the at-fault driver. People should also understand that their no-fault insurance could be coordinated, which means that they first have to turn to other disability insurance and have them issue their payment before you can have no-fault have to pay you any work loss. So there's some issues there to determine in terms of other disability insurance you have available to you.
What can you sue the at-fault driver for when you've been injured in the Michigan car crash?
You actually have limited damages that you can pursue against an at-fault driver. You can pursue some vehicle damage if you don't have your own insurance coverage for it. That's capped up to $3,000. But you can also pursue pain and suffering damages and excess economic loss that's not covered by Michigan no-fault insurance. You should understand, though, in terms of the right to pursue those damages, they're subject to unique standards, and there can be situations where people aren't able to claim something like pain and suffering damages because of the special rules that apply to those claims under the Michigan no-fault law.
Who pays for the pain and suffering damages?
You pursue your pain and suffering damages against the at-fault driver. Also, the owners of vehicles driven by at-fault drivers, they can be held liable. And if the at-fault driver is operating the vehicle in the course of his or her employment, the employer can be held liable. There are other ways other parties can be held liable depending on their relationship with the driver and how the driver is using the vehicle. You should also note that the right to pursue pain and suffering damages is subject to the threshold injury rule. That rule essentially says that you cannot pursue pain and suffering damages unless you have a serious injury, which is either death, serious disfigurement, which consists of amputations or serious scarring, and there's also serious impairment of body function, which most cases fall under, and that says that a person can only recover pain and suffering damages if they sustain an objectively manifested impairment that affects their ability to lead their normal life. And there's a whole set of legal principles that apply to those issues. The long and short of it is that people should understand that not all people are entitled to pain and suffering damages from at-fault drivers.
What happens if the at-fault driver does not have insurance?
There are situations where drivers get behind the wheel, they don't have insurance, and they seriously injure somebody. In that situation, it's unfortunate, obviously, the injury and the reality of no insurance. But what we hope to find is that the injured person is covered with uninsured motorist benefits through their own insurance coverage or coverage that is in their household. And the way that works is that the coverage is supposed to apply to the person who is injured by an uninsured driver, and the insurance company of the injured person steps in and pays the damages as if they were paying the damages on behalf of the at-fault driver. So uninsured motorist coverage is very important coverage for people to have, and there's also underinsured coverage, which applies in the same way, but that's in a situation where the at-fault driver has insurance but not enough insurance to cover your damages, and then you recover the rest of your damages from your own insurance company through your underinsured coverage.
If you're injured in a Michigan car crash, do you have to communicate with your own insurance company?
You do need to communicate with your own insurance company to a certain extent. You have to make them aware of the crash. You have to fill out their forms. You need to provide them information about your injuries. So there are some obligations you have to communicate with them. You should try to answer their questions as best you can. If there are disputes that arise, you need to consider whether you should contact an attorney or some other representative to advise you on those disputes. But hopefully people can communicate with their insurance companies and get their claims paid without needing a lawyer. I do have to say that sometimes it doesn't happen, but we hope that it does for everybody.
So if you've been injured or have had a Michigan auto crash, do you need to hire an attorney right away?
You need to immediately consider whether you should have an attorney. That depends on the facts of your crash, how much is in dispute. I say to all family members and friends, you're probably better off hiring an attorney.
Thank you, Steve.
Thanks.
In the Name of Personal Injury Law is brought to you by the Sinas Law Firm. In the Name of Criminal Defense.
Today we are joined by criminal defense attorneys Takura Nyamfukudza, Mary Chartier, and Marisa Vinsky. Now, we often talk about lengthy prison sentences that people serve for various crimes, but we don't talk about the conditions that they serve under. So we're going to talk today specifically with these three about solitary confinement. Now, I'd like to start with you, Marisa. Can you begin with an explanation of why this form of punishment is used?
Yeah, so one of the core missions of jails and prisons and the staff that work there are for order, control, custody of the inmates. So they want to make sure people that are incarcerated are sticking to the institutional norms and codes and conducts, and anything that deviates that can result in punishment.
So is solitary confinement generally just used when there's violations or infractions of these institutional norms that Marisa just mentioned?
No. And that's one of the big issues. The other big issue, of course, is the unbelievably negative impact that it has on the people who are placed in solitary confinement. But the argument that is frequently made in support of solitary confinement is that we need to do this because we need to enforce the rules. But frequently, people are placed in solitary confinement for very minor infractions, being out of place, not eating their meal fast enough, things that even if you supported solitary confinement, which we frequently do, we of course do not, but even if you did, the infractions frequently are very disproportionate to the solitary confinement of the individual.
So have there been studies conducted about the conditions that these prisoners are living under when they are in solitary confinement?
Yes, there have been, Lisa. And according to a study spearheaded by the Yale Law School, restrictive housing, which is the official name for solitary confinement, during the summer of 2021, there were between 41 and 48,000 people living under these conditions. And these are folks who are staying in cells by themselves, and these cells are smaller than a parking space for an average 22 hours a day. And of those 41 and 48,000, about 6,000 of these men and women were in solitary confinement for over a year, Lisa.
So what do we know about the impact that solitary confinement can have on the individual prisoner?
A lot. So there are so many mental health consequences from being isolated from other individuals. And I think it's so interesting that Takura called it restrictive housing. That's kind of the sanitized version that people who are in support of solitary confinement, that's the wording they're trying to use. Remember when people were being tortured and then the government was calling it enhanced interrogation. Solitary confinement is really torturous, and everybody can imagine that during the lockdown. Some people who were home alone, even though they had access to Netflix and Zoom and telephones, were really struggling mental health-wise, and even people who had family at home were really struggling with not being able to socialize. And then you put people in a cage, as Takura mentioned, which is so small, and of course they're going to have really serious mental health issues, post-traumatic stress disorder. It enhances other issues that individuals are having. And we have a client who spent over 11 years in solitary confinement, and he was a juvenile lifer. We're trying to get him out of prison. But whatever issues he had when he went into solitary confinement were certainly not treated during that time frame and were made significantly worse. I think it's torture. It really is torture for individuals.
And suicide rates and self-harm are significantly higher than people who are incarcerated in general population. As they both mentioned, imagine being in a small room 23 hours a day by yourself. And there's actually, Mary mentioned Netflix, there's a great documentary on Netflix about Khalif Browder. He was actually in solitary confinement for 2 years on Rikers Island. He wasn't even ever convicted of any crime, and he was put in solitary confinement. And unfortunately, after he was released, he committed suicide. So that is a significant problem that comes with solitary confinement.
So are there any states that are trying to address the issue of the problems that arise out of solitary confinement?
Yeah, so California actually is discussing legislation right now. I believe it's called the Mandela Act, and they want to conduct more research and studies on individuals who are in solitary confinement. The legislation proposes that pregnant individuals, individuals under the age of 26 and above 59 are not allowed to be in solitary confinement because of the extreme effects that it causes on individuals.
Lisa, we know that in 2021, New York State passed similar legislation, and fortunately, the list continues to grow. There are 3 states, Delaware, North Dakota, and Vermont. Those states reported having zero inmates in restrictive housing. And we know that there are 2 states who reported having fewer than 10 in that year. So, yeah.
So, Marisa, you've done a lot of research on this issue. Do you have any final thoughts?
As Mary and Takura both mentioned, we are, not advocates for solitary confinement. The structure really needs to be looked at because people's mental illnesses are really exacerbated, and there's actually a disproportionate effect between Black people who are incarcerated and put in solitary confinement and other races. So it's really an institution that needs to change and be looked at for the health and safety of those affected.
So, Takura, the amount of time spent in solitary confinement seems to scar a person for life. Do you have any idea who has spent the most time in solitary confinement in the United States?
So records show that Alex Woodfox, who was incarcerated in Louisiana's infamous prison, that spent 43 years. That's longer than I've been alive, Liisa.
Of course he's going to add that in. Thanks a lot.
Right. But he was released finally in 2016, and he wrote a book in 2019 which talked about his experiences spending all that time in a 6x9 foot cell.
So I have one last question. It has to do with your juvenile lifer case. So studies have shown that juveniles, their brain has not finished forming.
Right.
What kind of impact does solitary confinement have on a developing brain of a young person?
So Marisa has done so much of our juvenile lifer work, and whatever impact it has on an adult with a fully formed brain, it's like tenfold on a young person. We are social people as human beings, and that's what a lot of people forget. They think, prison, I don't care what happens in there, but these are community members, and people in prison are everyone's, brother, sister, mother, father, daughter, son, all of that. These are our fellow community members, and as a society, we have to be able to treat people better, and we certainly have to treat young people better. The impact on them, spending 40 plus years in solitary confinement is horrific. For most of the young people and the young person who Marisa mentioned, I really believe there was a direct impact between the solitary confinement and the suicide. Absolutely. Because sometimes you just can't overcome those mental health issues and the trauma that someone experiences when they're in solitary confinement. And as you know, Liisa, we discuss these issues and more on our podcast, Constitutional Defenders, and so I hope everyone takes a listen.
Thank you.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza, PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Family Law.
Today on In the Name of Family Law, we're going to talk about how domestic partners, especially our women, are at high risk when they're in the middle of divorce and custody litigation. I'm here with Nancy Gallagher, an attorney at the Gallagher Everitt Law Firm in mid-Michigan, and she practices family law. You've seen her before because we talked previously about a very tragic situation where her client was killed, murdered by her husband in a murder-suicide context, and also killed Nancy's client's child and mother, in addition to killing himself. So thank you for coming back again, Nancy. We had a lot more we wanted to talk about, really to help people learn how to protect themselves and maybe how to avoid this tragic situation that happened to your client. So let's start by talking about, when is a PPO used? Because your client did go to court and she tried to get a PPO to protect herself, and she was representing herself in that, but the district court denied her request. So can we talk a little bit about, what is a PPO for? Sure. and why maybe how we can make it work better in future cases?
Sure, there are standards in the PPO statute, for stalkers, but we're talking about domestic relationship PPOs, where if you're reasonably in apprehension of fear, then you document that in a petition, why you have a reasonable fear of this person. You ask a judge to issue a personal protection order, the value of which is that the police don't have to stop and ask questions if this person is bothering you again. There's a PPO, and it is a separate cause of action for violating the PPO. So it saves time. It also puts information in the law enforcement information network. So either of those names or the specific address pop right up, and to a police officer, it makes their job a little more efficient because they have some vital facts if they get a call. Doesn't stop someone from doing something, but it certainly gives law enforcement some tools.
Could slow them down as well.
Right, could slow them down.
What about, can a PPO help if the person that you're afraid of has a gun? If you know they own a gun, is that something that can help out with?
That is something that my client alleged in her petition, that he had a gun and he was threatening self-harm. He was threatening to blow his brains out, were her words, and she was afraid. Her petition was very clear in that regard. But I think, what I look at here is what can we learn from this? Mm-hmm. Is there something we can learn from this horrible tragedy? And unfortunately, it's not a terribly isolated incident, because something I read from a credible source said there's 11 a week murder-suicides in this country, and most involve guns, and the vast majority involve female victims. So it is unfortunately not an isolated tragedy. What could have been done is really something that a lot of people will be asking themselves.
So, in the domestic context, you said that she had to show that she had a reasonable basis to be afraid. Let's talk a little bit about the fact that he was threatening to kill himself. Yes. Why wasn't that enough?
Well, a lot of times,
should it be enough?
Well, a lot of times in these relationships that are characterized by coercive control, that is not always a lot of physical violence. It can be mental,
emotional, psychological,
and I'll leave all of that to the psychologists. But a lot of times, threatening self-harm is a means of control. In this case, he was also just blowing up her phone and just doing everything he could to insist that this separation and divorce
this is
not
once
happen.
He learned that she had filed for divorce, right?
Well, once he learned that she wanted him out, and he had been doing this. So women are just so dangerous when they're in so much danger when they're in a transition from a partner who is willing to even threaten to take their own life to stop that. But I think what we miss sometimes, and I mean all of us, is that when you're threatening to hurt yourself and you're in this relationship where you're trying desperately to control this person and not let them go, your threats of self-harm should be viewed as a threat to harm that person and a danger to them as well.
Right, even if it's not stated. Isn't the idea is like, well, if I can't have you, no one can?
Exactly. Right. And if I can't live without you, then I'm taking you with me. And in this case, your 13-year-old child and your mother. So it was extreme, but anyone who's done family law for any length of time has had these situations, and too often that's just divorce talk. Or the answer is, well, he hasn't done anything to her before. Well, she was never saying she was going to leave him before, and he was never threatening to blow his brains out before. That's a very dynamic and threatening situation. Even if he wasn't saying the words, "I'm going to kill you," that is very, very threatening. And I just hope that, we realize how much danger women are in the legal system, the friends and family, and you just see the devastation.
Right, because it's also his family that could have done something to stop, right? They know that maybe he's threatening himself. They know he has a gun, and I think they even knew that he claimed he was going to go and kill her. Right. Of course, nobody else knew about that. Right. And they did nothing. They didn't call 911. There's a mental health crisis with this person. Like this person should not be on the streets.
Right, and should certainly not be armed.
Right. So one thing, the judge who denied the PPO, she was representing herself for that, and she goes to a district court judge, and he's like, well, it's just self-harm. I'm going to deny it. Didn't he also say, well, you could go get what's called a temporary restraining order, or TRO, in your divorce case? Now, this is not a family law judge who's saying this, so tell us a little bit about what is a TRO? Was he kind of off base when he thought that was a solution?
And the only thing I know about what he said is what he wrote on the denial, saying that she could get a restraining order in her divorce. Well, restraining orders in divorces, since the advent and use of PPO, is typically regarding property. So
And money, right?
Property and money. Well, it's property. And not, I've had judges say, if you want to keep him out of the house, if there's a reason to, get a PPO. So I've had judges in family law say, well, she needs to get a PPO. And they won't typically, in some counties, issue exclusive possession of the marital home orders if there's not a situation that would also support a PPO. So it is kind of a catch-22, but I don't think that's the answer when someone is armed, threatening self-harm, and trying to prevent a divorce or separation. I don't think the answer is a restraining order in a divorce.
Right. So because women in transition are at higher risk of harm when they're trying to transition out of a marriage or a relationship situation, what recommendation do you have to help other women?
And this is so sad because I believe much of it is to do the things she did. Try to physically separate from him, get him out of your house, seek a PPO. Call the police if you feel threatened. I've been told there were calls to the police in the time after the PPO was denied. So I think, just looking at that case, she did a lot of those things.
But she didn't have an attorney for the PPO.
She didn't have an attorney for the PPO. I'm not sure. I can't say that would have made a difference. But I just think if the PPO would have been in lien, maybe it would have been a different response. I don't know. Apparently there was a call from the house, but I don't know at what time and at what point in this tragedy. So, but aside from this incident, if you need to leave your house, if you're don't feel safe in your house. But I think the important thing is just because he hasn't done this before, just because you're not someone that's been subject to intense physical violence, doesn't mean you're not in physical danger when you try to transition.
Thank you, Nancy.
Thank you.
In the Name of Family Law is brought to you by Speaker Law Firm.
Thank you for watching In the Name of the Law. We'll see you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.